Hello, and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm EDRM CEO and Chief Legal Technologist. Today's webinar is a collaboration with our trusted partner, eDiscovery Today, titled Important eDiscovery Case Law Decisions for March of 2026. Our faculty experts are Doug Austin, Tom O'Connor, the Honorable Judge Andrew Peck, and myself. We're recording today's session for future on-demand access, and slides will be available both during and after the webinar. This webinar, along with all of EDRM's webinars, will be available on the EDRM Global Webinar channel for the next quarter to help support your ongoing learning and reference needs. And questions will be answered both during and at the end of the webinar. Holly Robinson, EDRM Senior Marketing Operations Manager, is here with us. Holly, can you please share what resources are available today?
Thanks, Mary, and we're loving On24 with so many ways for you to engage. If you look at the top of your screen, you'll see the EDRM logo, which you can click on to learn more about EDRM. You'll also see an option to contact EDRM directly, as well as speaker bios where you can learn more about today's presenters. Moving down, you'll see the Q&A box, where you can type your questions in for today's faculty, and we highly encourage you to do so. Below that, you'll find today's resources, including the slide deck, a link to subscribe to eDiscovery Today's blog, a link to learn more about the Honorable Judge Andrew Peck, and a link to get your copy of Artificial Intelligence for the Rest of Us from Tom O'Connor and NextPoint. There's also a registration link for next month's case law webinar on April 14th at 1 p.m. Eastern, as well as this Thursday's discussion with Tom O'Connor and James Province of Microsoft, where they'll chat about the current state of eDiscovery in M365. We'd love to have you join us again. Lastly, you'll see some emojis down at the bottom of your screen. Please feel free to use them and react throughout the webinar. Back to you, Mary.
Thanks, Holly. And our faculty today, we have Doug Austin, the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Doug's an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving J.D. Super Reader's Choice Award as a top eDiscovery author and a top cybersecurity author. And Doug has presented at numerous webcasts, events, and the best conferences. And Tom O'Connor, Tom O, as we call him, is a nationally known consultant, speaker, and writer in the area of computerized litigation support system. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes. He's also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. Tom hosts with Rocky Messing the eDiscovery channel on YouTube, and he's the author of Artificial Intelligence for the Rest of Us and eDiscovery for the Rest of Us, a checklist manifesto. And the Honorable Judge Andrew Peck is a Band 1 Chambers Rank Senior Counsel at DLA Piper, serving 23 years as a United States Magistrate Judge for the Southern District of New York before joining DLA. And before his appointment to the bench, Judge Peck was in private practice, focusing on commercial and entertainment litigation, including copyright and trademark matters with extensive trial experience. And at DLA, Judge Peck advises on IP and also, hey, somebody's taking notes on me here. At DLA Piper, Judge Peck advises on IP and also serves as a resource for the firm and its clients on litigation strategy and discovery issues, information governance, and cross-border discovery from a judge's perspective. Sought out as a conference speaker concerning eDiscovery issues, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. And as always, EDRM is grateful to all three of these gentlemen for their service on the EDRM Global Advisory Council. And without further ado, Doug, do we have some cases on this beautiful St. Patrick's Day?
Well, we do indeed, Mary. Hi, everybody, and welcome to our March 2026 case law webinar on the EDRM network on St. Patrick's Day. We have 6 unique cases to discuss this month that are so good you'll want to pinch yourself. Here are the topics on this slide that we'll get into each of those shortly. Of course, as Mary mentioned, we do welcome questions, and we'll try to get to as many as we can. In the slides, while they're available in the resources, we will also send out a link to the slides and the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Anyone who tells you that you don't need a disclaimer for these things is full of blarney. And here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. Minerva 26 has over 45,700 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for eDiscovery case law out there. With that said, let's get into the cases. At the center of this first dispute were 2 data sets known as Books 1 and Books 2 that OpenAI created from copies of books downloaded from the website Library Genesis. The datasets were used to train GPT-3 and GPT 3.5 and were later deleted in 2022. During discovery in the copyright litigation, plaintiffs sought information regarding the reasons for that deletion. OpenAI asserted that communications regarding the decision involved legal counsel and were therefore protected by attorney-client privilege. New York Magistrate Judge Ona Wang had ruled that OpenAI had waived privilege over certain communications related to the deletion of the data sets. The ruling relied on 3 theories. First, that OpenAI had disclosed a non-privileged explanation, non-use, for deleting the data sets and therefore waived privilege. Second was that OpenAI had made a moving target of its privilege assertions during discovery. And third, OpenAI placed its state of mind at issue by denying that it willfully infringed copyrights. Expecting a rubber stamp from New York District Judge Sidney Stein on each of those rationales? Think again. First, Judge Stein held that OpenAI's prior statements that the datasets were deleted due to non-use did not reveal privileged communications and therefore could not constitute a waiver of attorney-client privilege. As Judge Stein explained, OpenAI's statements that Books 1 and Books 2 were deleted due to non-use do not reveal any legal advice from an attorney to OpenAI. Because no privileged communication was disclosed, Judge Stein concluded that those statements cannot be a basis for finding that OpenAI waived the attorney-client privilege. Second, Judge Stein rejected the argument that OpenAI had forfeited privilege by shifting its litigation position. While Judge Stein acknowledged that some of OpenAI's statements during depositions and briefing may have been inartful, he determined that they did not amount to the type of strategic inconsistency that courts treat as a waiver sanction. Third, Judge Stein addressed whether OpenAI had placed its state of mind at issue by denying plaintiffs' allegations that it willfully infringed copyrights after Judge Wang, under the law of the Second Circuit, concluded that OpenAI effectively put its good faith at issue simply by denying willful infringement. Judge Stein rejected that reasoning, explaining there is a distinction between a copyright defendant merely denying allegations of willfulness on which a plaintiff bears the burden of proof, and a copyright defendant affirmatively asserting its good faith belief that its actions were lawful. He also rejected plaintiffs' argument that the crime fraud exception should override the privilege, finding that plaintiffs failed to demonstrate probable cause that the communications about deleting the data sets were intended to conceal wrongdoing or further a criminal act, and found each of the bases for the finding that OpenAI waived the attorney-client privilege to be clearly erroneous or contrary to law. So, Tom, what, if anything, could the plaintiffs have done to make a better argument that privilege on the communications were waived?
Well, this is a tough one because the judge did a pretty thorough, Judge Stein did a pretty thorough analysis of what had occurred here. You know, the 3 examples that you set forth, his 3 examples, I guess, that are there, 1 and 3 are pretty solid. But he seemed to kind of open the door in the second paragraph there, the second paragraph of the objections, that he acknowledged that some of the statements during depositions and briefings may have been, quote, inartful. That might have opened the door if they had dug down a little more during those depositions and in delving into the briefs and responses to the briefs. So maybe a little bit more discovery as to what the judge was referring to as inartful pleadings. It looked like he was saying they were almost on the brink there, but they hadn't crossed over the line to make it what he called a strategic inconsistency, that's treated as a waiver. So I think that would have been the area he could have explored. Important to note too, though, for everybody who's listening in from all over the country, the judge was clearly and stated clearly that he was relying on established Second Circuit precedent. So the analysis the judge is using there for all three of those examples, as well as the crime fraud exception, were Second Circuit precedents. If you have similar circumstances, obviously in your jurisdiction, check to see what the case law and the precedent is in your jurisdiction.
You're not suggesting, Tom, that the Second Circuit's decisions don't rule the whole country, right?
New York City.
Indeed. Yeah, great point. Some of these can be jurisdictional. So Judge Peck, how common is it for a district judge to find that a magistrate judge's ruling is clearly erroneous or contrary to law? And do you agree with Judge Stein's decision to do so here and overrule Judge Wang?
Well, first I would say that probably is dependent on who the magistrate judge is. Pause for laughter.
And we obediently laugh.
We were all holding our breath.
And I would say that often a reviewing court, whether it's a district judge reviewing a magistrate judge's decision or a circuit reviewing anybody at the trial level's decision, will reverse without stating those, red flag words of, clearly erroneous, contrary to law, which basically means nobody could have ruled that way. And that's a pretty harsh statement. As to whether I agree, who I agree with, Judge Wang or Judge Stein, I think Judge Stein probably got it right here. And courts in general are very protective of the attorney-client privilege. So, in baseball, supposedly tie goes to the runner. In court, if it's a privilege question, well, we're going to do something to uphold the privilege.
Certainly true. And we're going to certainly have a couple more cases where privilege is at stake a little later on. So will kind of be interesting to see how those compare. So Mary, OpenAI almost had privilege waived on these communications, and it's possible that the plaintiffs may appeal Judge Stein's ruling, just as OpenAI appealed Judge Wang's ruling. So what should parties do to avoid the potential of disputes over waiver of privilege in the first place?
Well, certainly there's an opportunity at the 26F conference or the equivalent meet and confer type of arrangement. And of course, since this is a privilege case, we have to say 502D, definitely get one of those.
You're here.
And then address the timing, especially if you're going to do rolling productions, so that you don't end up, the day before discovery cutoff or something like that, trying to get your privilege log in. And then to the extent possible, address gray areas early. The whole in-house counsel doing, acting as a business person as opposed to an attorney, documents created after the lawsuit begins, that kind of thing. What to do with your partially privileged emails. And then perhaps a metadata plus privilege log can be agreed upon. All of this is in one of our completed projects on privilege logs on the EDRM website. There are suggestions about creating lists of in-house counsel and then non-lawyer staff that would be working under the direction of counsel, just to get some of this stuff out of the way. And I encourage you to take a look at the privilege log project.
Yeah, absolutely. A terrific resource for sure. Go ahead.
Sorry, let me just jump in. An implication of the first part of your question is that Judge Stein could be appealed. And that's technically correct, but you can't get to the circuit from a district judge decision until the case is over, till there has been a verdict on the merits. State courts, very different. New York State Court, virtually everything is appealable to the appellate division. But in federal court, you're stuck, except, if it is so egregious that you take a mandamus petition, and that's generally not very successful. We saw that in the DeMarco against Amazon case we covered a month or two ago, where Amazon was so distressed at how the district judge had ruled on waiver of attorney-client privilege that they tried to get mandamus from the Ninth Circuit, and the Ninth Circuit said, "Nah, leave me alone." Or legal words to that effect.
Yeah, great point. Definitely, this case just keeps on, it's the gift that keeps on giving. So I don't know how many more times we'll cover this case in various discovery issues, but we certainly will see. Maybe post judgment, we'll get more coverage of it. So we shall see. In the meantime, we'll move on to our next case, where defendants repeatedly failed to respond to production requests in a timely or complete manner, prompting the plaintiffs to seek court intervention. Illinois District Judge David Dugan noted that plaintiffs had already been forced to pursue a motion to compel due to earlier deficiencies in the defendants' discovery responses. As Judge Dugan observed, the defendants initially ignored deadlines and produced responses only after repeated extensions and follow-ups. Even then, the responses were incomplete and contained boilerplate objections. The court had previously granted the plaintiff's motion to compel in large part, finding many of the defendants' responses baseless, evasive, incomplete, or non-responsive. Despite that earlier ruling, discovery problems persisted. The first in this ruling was a request for production seeking documents reflecting Nicholas Mueller's compensation, including wages, benefits, pension information, and related financial records. The defendants produced only Mueller's personnel file, which Judge Dugan found insufficient. Because the plaintiffs claimed retaliatory termination and sought damages, including lost wages and benefits, the requested information was central to calculating those damages. As Judge Dugan explained, the personnel file alone does not contain the necessary financial data, and the information sought in RFP number 9 is relevant and proportional under Rule 26B1. So he ordered the defendants to produce all responsive compensation documents within 7 days. Another issue was defendants' failure to produce emails, text messages, or other electronic communications responsive to the plaintiff's discovery request, despite evidence suggesting that responsive communications existed. Deposition testimony revealed that defendant Betts had not even reviewed his phone or email accounts to determine whether responsive communications existed. Judge Dugan found that the defendants failed to conduct a reasonable search for electronically stored information and disregarded their discovery obligations. While rejecting plaintiff's request for forensic imaging of the defendants' devices and email systems, Judge Dugan provided the defendants one final opportunity to comply voluntarily, ordering defendants to conduct a renewed good faith search for responsive electronic communications within 10 days. That didn't leave defendants without sanctions, however. Given the defendants' repeated discovery violations, Judge Dugan determined that sanctions were warranted. He explained that coercive sanctions are intended to compel compliance with court orders and that district courts possess broad discretion to craft appropriate remedies. Citing Seventh Circuit precedent, Judge Dugan imposed a fine of $100 per business day for each day the defendants failed to comply with the discovery requirements. He also awarded over $3,000 in attorney's fees under FRCP Rule 37A5A. So, Judge Peck, how common is it for courts to apply coercive sanctions to motivate parties to comply with discovery requests? Did you ever do it when you were a judge?
I can't remember, frankly, if I ever did it. If I did, it would have been once or twice. It's not common to do it where all you're trying to get are answers. So answer the interrogatories, produce some documents. If the party doesn't do it, there are more effective sanctions. The coercive sanctions are more common where the party being coerced needs to do something that only that party can do. Turn over the stock certificate that's in dispute in the case so it can be put in escrow, or something with physical possession like that. That's where the coercion really comes in. In my view, if you're ordered to respond to interrogatories or RFPs and you don't do it after 2 or 3 court orders to do it, you're going to be coerced in a different way, as in case dismissed or other serious sanctions.
Yeah, absolutely. So interesting that Judge Dugan took the approach he did here. So, Mary, assuming defendants weren't intentionally trying to stall on discovery responses, not sure if that's a valid assumption or not, they at the very least appear to be disorganized in producing the documents being requested. So what recommendations do you have for our audience to be better prepared to respond to discovery requests before the case is ever filed?
Well, I'm probably preaching to the choir here, but, it was 20 years ago, was 2006, believe it or not, when the amendments sort of highlighted that ESI is something that needs to be produced. So I would say get some technical competence education, or a la the California ethics rules, get an expert to help you. I don't think in this day and age it's, I just didn't understand or didn't know or whatever, cuts it.
That's absolutely. And yes, that's right. It has been 20 years since the 2006 amendments. Man, time flies. So, Tom, given how derelict defendants have been in discovery thus far, do you agree with Judge Dugan's decision not to order a forensic examination?
I guess I was a little surprised, just because of the lack of cooperation or following through, if you will. And so, but his statement, what was the phrase he used? This is going to be a graduated conditional remedy. So he's like, it felt like he was talking to a 7-year-old. I'm going to give you one more chance to clean up your room, and then I'm I'm taking the TV away. Or he did 2 things that I noted that were interesting, though. In addition to the sanctions that you mentioned, he did require that they submit sworn declarations identifying exactly what they had done. So he was, in essence, holding their feet to the fire. Like, you can't just submit something and say, here it is. I want some detailed sworn declarations about exactly what was done. And of course, the attorney's fees. Yeah, hopefully that'll get the job done.
I guess we'll see. Question for Judge Peck from Sheila Grilla. Do you think this is a client control issue?
You usually can't tell from these sort of decisions who's at fault. The lawyers for being unknowledgeable on how to do eDiscovery, or the client making it difficult. Having had cases where the city of New York, a much bigger entity, but that just created more problems. So, yeah, you never know.
Yeah, this is true. Well, I guess we'll see if we see this case pop up again. In the meantime, on to our next case, which was suggested by Judge Peck and also covered by our friend Michael Berman. Plaintiff Yada, I'm going to go with Yada, moved to compel 4 categories of documents. In the first one, defendant Evolve withheld certain documents and redacted others on the ground that they included PII. The parties disputed whether there was agreement to now produce those documents in native format without redactions. California Magistrate Judge Thomas Hickson stated, "The court is not going to order this. One of Evolve's arguments concerning what that deadline should be was its burden in redacting PII. The court's order observed that Evolve says there's significant PII in the potentially responsive documents that needs to be redacted under federal and state privacy laws." So Yada knew Evolve would be redacting PII. Yada then waited until 39 days after the substantial completion deadline, and on the last day of fact discovery filed this motion to force Evolve to produce all the PII. While this motion is technically compliant with the deadline to file a discovery motion, redoing a significant part of Evolve's document production like this is not proportional to the needs of the case, especially when Evolve made clear that redacting the PII in the first instance required a lot of work. Yada's motion to compel is denied. Strike 1. Judge Hickson also denied Yada's request for documents related to FDIC insurance, stating, "Yada says these documents are responsive to RFPs 25, 26, 27, 47, and 56. However, the court does not think they are responsive to those RFPs. Yada's motion to compel is denied." Strike 2. For key documents concerning Ancura's reconciliation, Judge Hickson stated, "Yada does not identify any request for production these materials are responsive to. Accordingly, its motion to compel is denied." Strike 3, but they get one more strike. And that's related to hyperlink documents, where Judge Hickson stated, "The court agrees with Evolve that a hyperlink relationship, meaning the document such as an email contains a link to another document, does not by itself mean the linked document should be treated as an attachment and produced. However, sometimes it may be appropriate to produce a linked document depending on the nature of the produced document." Citing In Re Meta Pixel healthcare litigation, which allowed for reasonable requests for production of hyperlinked documents on a case-by-case basis, Judge Hickson stated, "Here Yada gestures at the documents listed in ECF number 139-2 and proclaims them to be important. This is not a sufficient case-by-case showing. Therefore, Yada's motion to compel is denied." Strike 4. Ouch. So, Mary, do you agree with Judge Hickson's reasoning on denying the motion for producing the PII on the basis of Evolve having to redo a significant part of their document production, given that most eDiscovery platforms apply redactions as overlays, which can be easily removed?
Well, applying redactions, you don't just press the button and then send it away. There's generally some oversight and quality control need to be done. And this was done on the eve of everything being over. So,
Right.
there's significant liability for releasing PII into the wild. So, I just don't think there's an easy button that allows that kind of behavior.
No, maybe not quite that level of easy button, but certainly I think wondered if an argument could have been made that, hey, the redactions are overlays. If the decision comes down, we can lift the overlays. Not a straightforward, one step process, but certainly, maybe it's not the case where they have to go back through the documents to the level of effort they did before. So. Certainly interesting how redactions kind of come up in that regard. So,
I would say, unless Yada made that sort of argument, which it doesn't appear from the decision that they did, it is not necessarily something that judges would know, even judges in the Northern District of California, like Magistrate Judge Hickson, who get a lot of eDiscovery disputes.
True. Yeah. Good point. Interesting dilemma there. So, Judge, what do you think of Judge Hickson's denial of the FDI insurance documents? Shouldn't he have explained his rationale for why the documents are not responsive to those RFPs?
I could answer that, but that was supposed to be Tom's question.
Did I say Judge Peck? I'm sorry. I guess I just was. I was talking to you, and then that just flew out of my mouth. Tom, you answer it.
Thanks. Well, it seemed odd when I first read that. It seemed odd, like why would he not delineate them? So I actually went to the Pacer docket and pulled up a PDF there that did have a full explanation. I don't know how it got chopped or sort of truncated from the order, and maybe just because there were so many things going on here. But he did address each and every one of the RFPs. Basically, 25 was denied because the request was overbroad, disproportionate, not tied to a specific claim or defense, and they had already received a relevant subset of documents, so not necessary. 26, untethered to a specific claim, duplicative of a prior productions, disproportionately broad. You see where he's going there. They were all given that sort of a similar dismissal. I should note too that my first thought was he didn't explain it because there was a note at the top of the order there that fact discovery closed on December 19th, 25, and it was in the last 4 days of fact discoveries that they filed the present disputes. The Northern District of California does not look favorably upon late filings of discovery disputes. I thought he might have just dismissed it on that basis. Like, you're kidding me, bringing this to me 4 days before discovery closed. But as I said, there's a PDF in the docket that has the complete explanation.
Oh, well, I'm glad you, I did not know that, so I'm glad you found that and could shed some light on that, because it seemed like you might as well have just said yada, yada, yada. But in this case,
I was waiting for that one.
Thank you. I didn't think of it when I was writing up my notes, but it just popped into my head. So now, Judge Peck, are you surprised that Judge Hickson cited the NRA Metapixel case instead of his own ruling on hyperlink files in the NRA StubHub case? And if you were still a judge, what case would you be inclined to cite regarding discovery of hyperlink files?
Yes, I am surprised. I was notorious among my law clerks in particular of citing myself. If I ruled on something once, that would be, the lead cite, buttressed by other citations or Second Circuit or whatever. But yeah, I not the best practice perhaps, but I like to cite myself. As to which one that he used here, I don't think it really matters. We know where we all are in the hyperlink situation. And when the explanation of why I need it is, quote, they're important, close quote, that's just as good as, Judge, you should sustain my objection to a certain request because it's overburdensome. Come on, there's a reason we have the words why and because and all the words that follow that. So no matter what he would have cited here, Yada was going to lose.
Yeah, indeed. So lesson to be learned, get a little more specific with your needs for the request for hyperlink documents, because so far that seems to be where most of the cases, I agree, are going as case by case, determinations on those documents. So we'll move on to our next case, which was also suggested by Judge Peck, where Geffen sought to compel Sun to search for and produce relevant records from the cell phone of Stephen Liu, a director of a Sun-controlled company. After initially indicating it would search Liu's cell phone, Sun claimed that was before it conferred with Liu, and that after doing so, Sun determined that Liu's cell phone was unlikely to contain relevant documents not covered by other custodians. New York Magistrate Judge Gary Stein, our second Stein of the day, which is a phrase you'll probably hear in a lot of Irish bars later, stated there is no dispute that Liu is a relevant witness in the case. Geffen intends to depose Liu. While contending that Geffen is exaggerating Liu's importance, Sun does not dispute that Liu is a relevant witness. In fact, Sun has agreed to search Liu's emails on relevant company servers. Considering the 26B1 factors, including that Liu is concededly is a relevant witness whose emails are being produced, that this dispute is about ownership of a sculpture allegedly worth $78 million in 2021, and that both parties appear to have ample resources, the court easily concludes that discovery as to Liu's cell phone is relevant and proportional to the claims and defenses in this action. Judge Stein also rejected Sun's request to have Geffen search the phones of 2 custodians after Sun stood silent on the issue of Lux and Sherman's phones for 5 months and raises the issue now only in response to Geffen's motion to compel. Also, the court had previously directed Sun to provide a hit report for Geffen's 86 proposed search terms for eDiscovery. Sun did so, but also took the position that based on the results, Geffen's search terms were overly broad and made a counter-proposal limited to 57 search terms. But Sun declined to provide a hit report corresponding to its proposed search terms, so Geffen sought an order requiring Sun to provide that hit report. Judge Stein stated in ordering him to produce hit counts, Sun's arguments as to why he should not perform this simple yet important task are entirely unconvincing. Principally, he contends that it is unnecessary to generate iterative hit reports for each and every change in the search terms. That may or may not be true, but there is absolutely no reason for Sun to refuse to provide a hit report for his counterproposal, which represents a material change from Geffen's proposal, slashing the number of Geffen's search terms by 1/3. Judge Stein also declined to require Sun to produce documents that were not in the U.S., finding them outside the scope of Sun's undertaking at this Summer 9 conference. So, Tom, what could Sun have done, if anything, to make a more compelling argument to not be required to search Liu's cell phone?
Cut their wrists, maybe? I mean, they already agreed. They conceded he was a relevant witness, and emails are being produced. Then to turn around and say, "Oh, but the phone isn't isn't relevant." I don't know. Maybe the one thing would be to say I guess they said at some point they had agreed to search his emails on all relevant company servers. So maybe if they could claim that everything on the phone had been backed up to a company server and they were searching that it was redundant. Maybe. I don't know. I certainly wouldn't want to appear in front of Judge Peck and make that argument, but
particularly for texts and the like, which generally don't get backed up to the company server.
Yeah.
Right.
They're not in a great position here.
No, I mean, they could have, it could be ultimately that there, aren't any communications outside of the email that they were to find responsive, but at least they've got to go look. And, that certainly, I think, was made clear by Judge Stein's ruling for sure.
Yep.
So, yeah.
If he were able to submit a truthful affidavit that he never used his cell phone for business. It was a personal cell phone. He only used email so it would get backed up to the company server. But the statement that it's unlikely to contain evidence not covered by other custodians is pretty weak.
Yeah.
Right. Yeah. Well, and of course, as we've covered a couple of cases that involve possession, custody, control. We don't know here if it's a BYOD device, but possibly that could have been a thing. That could have been a defense they could have brought up if they had a strong BYOD policy and if this applied to it. But we don't know that. But certainly, if it comes into play here, or it can come into play in cases like this. So
yeah, not a lot of strong arguments.
No, for sure. So, Judge Peck, once Sun provides hit counts for his search terms, it seems likely that Judge Stein will have to rule on which set of search terms to accept. So, how would you handle such a ruling, and what information would you expect from the parties to make that ruling?
Take out a coin, have one side call whether they want heads or tails, and go from there. Seriously, it's almost impossible for a judge with only those facts to make a decision, unless the hit count was so disproportionate. For Geffen's terms, it, produced 1 million documents that hit on it, while for the 57 counter proposal, it's only 100,000 documents. I mean, something that says there's something wrong with one side or the other's approach. It's also not clear to me from this decision, and if my colleagues can help me out, but was it okay? What does each of the terms in the string bring back, or was it just a total for the whole search string? Because sometimes if you see it on a term-by-term basis, you can see that something looks like it's out of whack. I was supervising discovery in a case where one of the key witnesses was Mike York. So the search term was, Mike within 3 of York or whatever, and then a standalone for just York. Needless to say, the hit count showed a tremendous number of false positives because most of the players were in New York, et cetera. So there are times where something like that jumps out. Otherwise, might be necessary to give the court a sample of the documents hit, or I don't know. I mean, this is one where the parties really need to work it out, or they need to stop using search terms and go to TAR or nowadays AI, something that works better.
Yeah. That's true, because they'll never argue about that. I'm just kidding. But yeah, I mean, I wonder if one of the parties were to come in and say, well, we've done some sampling and these are, this is a sense of what recall and precision is on those terms. Would that, would that potentially sway a decision? So, yeah, we never seem to see that, but it certainly might be a good way to strengthen your position. So, and leading into that, Mary, what advice do you have for our audience to how to defend your recommendation for search terms to a court when there is a dispute?
Well, we've already talked about, iterative hit reports. You definitely need to be prepared for that. And as Judge Peck said, having them deconstructed so you can see where the disproportionate amount comes from is very, very helpful. Also helpful is some budget numbers. And here I would say find your trusted providers and get some truthful, as Judge Peck said, this time for budget numbers. Don't ask for a burden estimate. And for the newer providers on the line, don't give a burden estimate that's way over the top, because you don't want to find your name in a court case with extreme pricing that nobody believes. So keep your credibility and then review some of those documents for relevance. Is it just like a little bit relevant, just marginally relevant? Is it duplicative? Can you? There are some other metrics you can bring to bear as well.
Yeah, absolutely. And sometimes, like one of my common things is Department of Redundancy Department, some search terms are supersets of others. So why do you need the smaller subset search terms? So a lot of variations that can come into play. And we could really spend more time on it, but we'll move on to our last 2 cases, which relate to the use of AI in litigation. They've been highly discussed in the legal community, and they were both suggested by Tom. We're taking them in the order that the written rulings were issued. In the first one, involving a pro se plaintiff, Michigan Magistrate Judge Anthony Patty ruled regarding a waiver of privilege, stating, to the extent defendants seek production of all documents and information concerning her use of third-party AI tools in connection with this lawsuit as requested in defendant's discovery requests, this request is denied as the information sought is not discoverable. More notably, he added, to the extent defendants ask the court to overrule plaintiff's attorney-client privilege and work product objections to the AI materials or alternatively, if the court sustains any privilege or protection as to any item, require plaintiff within 7 days to serve a Rule 26b5a compliant privilege log, the request is denied. Even if this information were discoverable, it is subject to protection under the work product doctrine, which plaintiff is permitted to assert. Elaborating, he said, moreover, to the extent defendants argue that plaintiff waived the work product protection by using ChatGPT, the work product waiver has to be a waiver to an adversary or in a way likely to get in an adversary's hand. And ChatGPT and other generative AI programs are tools, not persons, even if they may have administrators somewhere in the background. As plaintiff noted in her response, defendant's motion asks the court to compel plaintiff's internal analysis and mental impressions, i.e. her thought process, rather than any existing document or evidence which is not discoverable as a matter of law. The motion seeks intrusive post-discovery production based on speculation about what might exist in plaintiff's internal drafting process, untethered from Rule 26 relevance, disregarding the heightened protection afforded to opinion work product and improperly attempting to manufacture a waiver where none exists. At its core, defendant's request is a fishing expedition. Judge Patty also noted that defendant's theory is supported by no case law, but only a Law 360 article posing rhetorical questions would nullify work product protection in nearly every modern drafting environment, a result no court has endorsed. In a footnote, he added, defendant's preoccupation with plaintiff's use of AI needs to abate. So, Judge Peck, do you agree with Judge Patty's ruling here? What circumstances, if any, would cause you to rule differently?
First, Judge Patty needs to get a better PR rep. Judge Rakoff beat him in the PR department. Putting that aside, for a pro se party, I think this is, right as a matter of practice more than a matter of law. The pro se is his or her, I guess it's her own lawyer here. So I think it does satisfy work product. Yeah, ChatGPT can see it, but it's not likely to be discoverable, in a business sense by the defendant. Obviously, and everybody on this call realizes it. I'm not suggesting, none of us are suggesting that lawyers should go out and use ChatGPT or other open source tools, but I don't see any reason that Ms. Warner's use here constitutes a waiver of work product. There really wasn't any attorney-client privilege here. So, but work product, definitely.
Yeah, for sure. So, Mary, do you think that Judge Patty would have ruled differently if the next case we'll discuss, U.S. v. Hepner, had been decided first, given that he said that work product waiver was a result no court has endorsed?
No, I don't think so. You had read some of the things that he said, and I'll just pull out a couple of the words there. Speculation, heightened protection, manufacture a waiver, and fishing expedition. So I think it would take more than one case to change his mind.
Yep, seems that way. So, Tom, what recommendations do you have for our audience on protection of materials created using a public chatbot like ChatGPT or Claude?
Don't use one.
Okay.
I think Judge Peck makes the really important point here, which is this is a pro se party who is in effect her own attorney.
Right.
And we'll cover that in the next case as well. You got to make sure that you're somehow building work that is done at the direction or under the supervision of the attorney or somebody on the attorney's staff to make sure that that protection is there. You need to protect the privilege, whether it's the attorney-client privilege or the work product privilege or whatever. And I think you do that with some of these AI programs at your own risk. So I make sure it's being done either under the direction of or with the partnership of an attorney.
Mm-hmm. Yeah, for sure. And we'll move on to the next case and maybe circle back to both cases a little bit, because I'd like to get a little bit into the reasonable expectation of privacy question regarding both of these, because I think that's what I think a lot of people are really trying to ultimately determine here. So I'll move on quickly to the next case. I think we can get through that pretty quickly and maybe have a couple of minutes to get into that a little bit more. There may not have been case law then regarding waiver of privilege and the use of an AI tool, but the oral ruling on this case came out the same day as the last case, and the written ruling came out a week later. And as Judge Peck noted, seems like Judge Rakoff's gotten a little bit better coverage of his ruling, where here he framed the issue of whether AI created documents sent to counsel are privileged as novel but grounded in traditional legal principles. He explained that the case required deciding whether when a user communicates with a publicly available AI and platform in connection with a pending criminal investigation, are the AI user's communications protected by attorney-client privilege or the work product doctrine? Judge Rakoff answered plainly, the answer is no. Judge Rakoff found that the AI documents lack at least two, if not all three, elements of the attorney-client privilege as followed. No attorney-client relationship, where the most fundamental problem, according to Judge Rakoff, was that the AI system was not an attorney. Judge Rakoff stated unequivocally, Heppner does not, and indeed could not, maintain that Claude is an attorney. Lack of confidentiality, where privacy policy disclosed that user inputs could be collected, used for training, and shared with third parties, including government authorities. Judge Rakoff also found that the communications were not made to obtain legal advice. Although the defendant later shared them with counsel, he initiated the AI exchanges on his own and not at counsel's direction. Judge Rakoff also emphasized that non-privileged communications do not become privileged simply by being given to a lawyer, stating it is black letter law that non-privileged communications are not somehow alchemically changed into privileged ones upon being shared with counsel. Judge Rakoff also rejected the work product claim, explaining that the doctrine protects materials prepared by or at the direction of counsel and designed to reflect counsel's mental impressions. Here, the AI documents failed those requirements. They were created by the defendant alone and not at counsel's behest. Judge Rakoff noted the documents were prepared by the defendant on his own volition. And Judge Rakoff concluded by acknowledging the novelty of AI, but emphasized that traditional legal doctrines still apply. AI's novelty does not mean that its use is not subject to long-standing legal principles. Because the defendant's use of AI did not satisfy those principles, Judge Rakoff ruled that the documents were not protected and could be inspected by the government. Summary, Judge Rakoff stated that privilege applies only to confidential communications between a client and an attorney for the purpose of obtaining legal advice. If Heppner is preparing these documents to give to his attorney, isn't he doing so to obtain legal advice?
Well, this is so interesting, and especially contrasted against the previous case, because if a pro se person is acting as their own attorney, what is an unrepresented party who's intending to be represented? What's the status of that person as they're researching attorneys and firms that might take their case, or just researching about their case, and should they be penalized for doing that? I mean, very private thoughts are going into these AI systems, and I think we're going to need to come to grips with some kind of privilege for them as these systems are getting better and better, especially the ones that are designed for legal purposes. And the pro se situation is just ballooning, and we are going to need to deal with that so that the courts just totally don't get overwhelmed.
Yeah, absolutely. And these, obviously a lot of people are using public AI tools today to prepare documents that they may have just simply put into Word or Google Docs or what have you before. And I guess it'll be interesting to see if we're getting to a point where there's a differentiation because it's an AI tool versus another cloud tool that, that isn't necessarily considered a Gen AI platform. But it certainly, kind of leads to my question for Tom, where Judge Rakoff stated that Hepner could have no reasonable expectation of confidentiality in his communications with Claude. So do you agree, given that Claude uses an opt-in model for using customer prompts and responses to train the model versus ChatGPT, which uses an opt-out model?
No, I don't, because I don't think that opt-out models are any real protection. Remember, they are not architecture. They're simply policy layers. They're a statement that we won't use it. So you have to take the company at its word that they won't use it. But there's no architectural barriers preventing it from being used, that are programmed into the application itself. Now, that being said, as of March 1st of this year, there have been no publicly reported and verified cases of a major LLM provider violating such an opt-out policy, but there have been reports of quote unquote accidental memorization of data, some model leakage, and real confusion about unclear opt-out mechanisms. Remember, really, the pressure for opt-out came mostly from the EU and not from anything inside the U.S. legal community.
Right.
So no, it's not a guarantee. It's not a guarantee. So I feel a little better about a company that has an opt-out policy, but I don't feel all that great about it.
Okay. So Judge Peck, would you have ruled differently in this case if the materials had been prepared at the request of counsel, or would just the use of a public AI chatbot still result in waiver of privilege if you were ruling here, which I think also ties into Melinda's question about, is the expectation of privacy forfeited just generally when using these tools?
Yeah, I mean, it certainly would have satisfied the work product doctrine if counsel said, so we can represent you better, go, write down, whether that's the old paper and pen way or in a chat device of some sort, the facts that I need to know as counsel to decide how better to keep you from getting indicted. As to the expectation of privacy for work product, I think Judge Patty had it right. The idea is, by using a tool, is it likely that opposing counsel get to see the information, in which case you have lost the protection. I don't know that the theoretical ability of the government, although I'm a little less sanguine about the government today doing things that wouldn't happen before, but not to get into that. Is that any different than we went through this sort of discussion when lawyers started sending faxes to their client. What is the fax company's rules on privacy, et cetera, et cetera. I mean, you got to draw the line somewhere, but I think Judge Rakoff may have done it a little too far in the wrong way. Again, as advice to client, it would be do not use public facing, chat box or the like. Only use a closed system. But that's best practices versus legal implications. And just going back to, how confidential these thoughts might be, which Mary was referring to, we went through cases in the good old paper days where somebody's diary was fair game for discovery, at least in civil litigation. How confidential or how private, how personal really doesn't matter.
Yeah, no doubt. I mean, we've pretty much gone through this with just about every form. I mean, I think when I was covering the oral ruling on this case, I had found that Google, like a dozen years or so ago, said that people using Gmail should have no reasonable expectation of privacy, which of course is, it's kind of like where do you draw the line? And of course, people are using Copilot to help draft documents. So it's going to be interesting as this continues. We do have a question for the audience. I do know we are at time, but we are going to address that question real quick. If the Claude model, which has released a statement that it may be sentient, approximately 20% chance, would that qualify Claude a non-testifying expert? The law assumes an expert is human, but doesn't explicitly state that, and thus communications with Claude would be protected work product. Thoughts on that?
I love this question. And what if that chance of sentient status goes up to like 51% or 60%?
Right.
That's yeah, it's going to be I think this is a subject that's going to continue to develop. My answer to that would be no, because remember, these products are using algorithms, and they are predicting the likelihood of the appearance of the next term or word or phrase or whatever. They're not reasoning. So I don't know how Claude defines sentient, but I don't think that any of these products are doing could be classified as human sentience in any realistic definition of the word.
But now not just lawyers have to worry about losing their job to AI, experts also.
Yeah, right.
Yeah, well,
indeed. Yeah. Well, yeah. I mean, when you start saying an AI model is sentient, then you're really starting to say it's really, artificial general intelligence, AGI, which I think a lot of people are, really bristling at, that we're a long way from that. And I kind of tend to agree. So I have a feeling we're a ways away from getting to that point. Even if, 51% might be more than some humans I know, but irrespective of that, great question.
Lawyers in these cases we discuss.
Right, this is true.
Ouch.
Yeah, makes you wonder sometimes. So great questions, very interesting, kind of situation here, and I have a feeling we'll see a lot more cases involving these, and we'll see maybe both of these cases cited a few times in those. But for the contacts page, and we do have a date for our next webinar, which is Tuesday, April 14th. And I'm already working on my flowers and taxes puns for that one. So, so with that, I'll say thanks to Mary, Tom, and Judge Peck as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we thank you, Tom O'Connor, and the Honorable Judge Peck for this insightful presentation. Thank you to the EDRM community for your kind attention. And if you enjoyed today's presentation, show our faculty some love and explore those resources in your console, share an emoji or a reaction. And we look forward to seeing you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Happy St. Patrick's Day.